Good afternoon. I'm hoping my internet will be stable because it's not having the best signal, but we shall see how we go today. So today we are talking about the 5 dangers of not having terms and conditions. This is something that is a real concern because it is genuinely surprising how many businesses who don't have proper terms and conditions. They literally simply rely on what might be on the invoice, if there is anything even in the invoice, right? So I'm just going to give you quickly some hints and tips in terms of what you can make sure that is on your invoice that at least protects you, even if you have no other terms and conditions. I'm not saying you should do this in the sense of you should have proper terms and conditions over and above this, right? On your invoice, number 1, the name in terms of your client, and this applies to your specific terms and conditions as well, your contract. The name must always be their legal entity name. So for example, if you are working with a sole trader, you need to actually refer to them as John Smith trading as ABC Trading. If they are a limited company, you need to make sure it says the correct limited company name that is specified at Companies House. This is really important, okay? Remember, basics. Always put a date on the invoice. Always be clear in terms of the amount. If you are VAT registered, make sure the VAT amount is included, but also make sure you've put your VAT registration number on your invoice. Then make sure that you make it crystal clear as to when that invoice is due to be paid. Is it upon receipt? Is it within 7 days, 14 days, 30 days? And what are the ramifications if they don't pay it? Are you going to charge interest? Are you going to put a late payment in the sense of a late payment commercial acts? I can't remember the full name of it off the top of my head, but there is a specific act which allows you to add late payment charges if it's business to business. Make sure that the invoice has that basic information, okay? That gives you key things on your invoice. Now, going back to the 5 dangers in relation to not having terms and conditions, right? Number 1, you are putting your business at risk by not having terms and conditions, because effectively the other party can turn around and say, you know what, we're going to be reliant on our own terms and conditions. There's this legal term called battle of the forms, right? So you want to, as a supplier of services, make sure that it's your terms that are what the party is relying on. And if you have no terms and there is then a dispute, it is literally a case of your word against your client's word. So terms and conditions are a must. That is a big risk. If you don't have them, protect your business. Don't put yourself at risk. Number 2, if you another danger is your client doesn't then know where they stand with you. They don't know the specifics. They don't know what it is that you are actually contracting to potentially do, because there's nothing documented. So again, if you want to make sure that your clients are crystal clear as to exactly what your obligations are and also what their obligations are. It ultimately provides certainty and clarity to your client. Number 2, if you don't have terms and conditions, you are open to a maximum value in terms of a claim, because you're not limiting it. There's no way of you limiting any liability. Now, quite often in a contract, when it's actually written properly, is you're limiting the value of what the claim is to the value of the contract, and that's the maximum amount that can be claimed. However, if you have no contract, then you are therefore open to all sorts of potential liability that could be claimed against you. Next, we all know, and you all know, that I was a former lawyer. I was a litigation lawyer, so I would be arguing over contracts all day long. Legal fees are expensive. It is a waste of your time, your resources, costs. So if you do not have a contract, the risk of you entering into litigation is much higher, much more expensive, and what an absolute waste of time. By having a contract, having your terms and conditions, being crystal clear as to what the parties' obligations, etc. are, it means that the risk of litigation is reduced significantly. Now, it doesn't mean that there is never going to be a dispute, because sometimes disputes arise. But what you should be doing is that there should be a clause within your terms and conditions that's called an alternative dispute resolution, which basically means you need to be trying to find a way to resolve the matter before it even enters into the court arena. So many businesses, they go straight into the court arena, and most of the time don't even try. Now, there are some businesses that get so frustrated, they try, and they get no communication back, and therefore they have no choice but to put it into the court arena. But reduce the risk of having legal disputes. And the final danger, ultimately, you want your clients to trust in you, right? And if you do not have terms and conditions, you can potentially be seen by your client / customer as a cowboy. So if you want to instill confidence in your customer, and you're making it crystal clear in terms of what what all of the obligations are, then it instills confidence in them. So they are the 5 dangers, right? What I'm also going to share with you is, so that tells you quite clearly why it's so important to have them, right? So what should be included in your terms and conditions? And I'm going to do a very much a whistle-stop tour here. So first of all, you should have clear definitions, right? Because there are going to be words that you're going to use continuously within the document. You need to make sure that are clearly defined. The next thing that you need to be making sure is you need to make it crystal clear in terms of what the application of those terms and conditions are for. For example, you are making it clear that there is one document, and you cannot include any other documents other than these terms and conditions. What are the fees, the price? What are you actually going to charge, and how are they going to pay you? What are the performance obligations by either party? Something that often gets missed, anti-bribery. Yes, this is key legislation, and when it's drafted by a lawyer, you will have an anti-bribery clause. Indemnity insurance. So this is where you potentially are one party is indemnifying you against additional costs. So, for example, the client shall indemnify and keep indemnified the supplier from and against any losses, damages, liability costs, including legal fees and expenses incurred by the supplier as a result or in connection with the client's breach of any of the client's obligations under this contract. That gives you a clear indication of one indemnity. Limitation of liability. I talked about this a few moments ago. You can then limit. Now, there are certain things you cannot limit. You cannot limit in terms of death or personal injury, for example. What about in terms of intellectual property, confidentiality, processing of personal data? We go back to the rules of GDPR and data protection. You may need to make sure that they are very clearly stated in your contract. Something that's called force majeure. So this is a Latin phrase, and it is all about whether it's in terms of performance of the contract that is delayed as a result of circumstances outside of the party's control. So this could be, for example, weather. We have a tornado. We don't tend to have tornadoes in this country, but it gives you an example. Duration and termination. So how long will it remain how long is the contract for, and how do the parties actually terminate? What notice needs to be given, if any notice needs to be given for any circumstance? What in terms of, there is what's called an entire agreement clause, which basically means that this one document constitutes the whole agreement. You cannot assign it to another party. You cannot set off any liability which has been incurred against another invoice, other contract, etc. Severance. So if there's one particular clause within the contract that is not deemed to be to be legally binding doesn't mean the rest of it falls apart. It's just that one specific clause. There's in terms of the dispute resolution clause, the governing law. So what is the governing law? England and Wales, and also who has the jurisdiction to actually hear it, and then obviously the execution clause. So that is a whistle-stop tour of just key parts of properly drafted terms and conditions. So if you have got all the way through listening to all of this, right, then you now have the opportunity to get a free terms and conditions template. Now, this is only for service to service contracts, and it's literally as is. So you use it in the format that it is. If there are specific requirements that you need, then you need to make sure that you go and see a qualified legal professional to have your terms and conditions drafted. Now, this document, if you had gone to a law firm to get it drafted, it would cost you over £1,000. And I am giving you this template completely for free. Right? And do I mean it's really for free? Yes, it's free. So what you have is the terms and conditions template, and alongside that, you have a schedule. Now, the schedule is a really key part because that is where the specifics regarding the contract with your client goes in. So this is where you will put your details. It will be where you put your client's details, making sure that you put, how this should be properly done is again making sure the legal name is specified for both you and your client. What is both yours and their company registration number, and what is their registered office address? That needs to go in the schedule. You need to stipulate exactly what services you are providing and a detailed description, right? Include the price, include the term, all of this information, anything that is specific to this contract, to this client, you make sure is stipulated in the schedule. The schedule forms part of the entire contract, okay? And you need to make sure there is an execution clause at the bottom. The execution clause is for both on the schedule and the actual main terms and conditions. So please make sure that both documents are signed. You can use this document in something like DocuSign or Signable to use the e-signature, but make sure this is a properly drafted terms and conditions that you can use in your business. Now, there might be certain things that you want to tweak. That is a matter for you. But please be mindful that this has been drafted in the correct way, and therefore by you, I would not recommend amending the core document. You need to go and get independent legal advice from a qualified legal professional if you want to make sure that there is something that is different within this template. This template gives you a solid grounding and is far better than you trying to download something from the internet that has been cobbled together by somebody. So if you want this free, like I said, it's worth £1,000. If you want this free terms and conditions template, then what I need you to do is simply put in the comment terms, and I will give you the link, and you can then download it. So you have to have listened to the end of this to be able to actually get this document. So make sure you put in the comments the word terms, and I will send you the link. Thank you all for listening, and I hope you found today beneficial, and I shall see you all next week. Take care. Have a great weekend.